Welcome to Looking at Legal Stuff. Today we have a motion to recuse the judge in a case with a high-conflict couple who have already had a bench trial that resulted in a parenting plan that Dad feels was unfair to him due to the biases of the judge. Some of his claims against the judge include the judge making inappropriate remarks about his appearance and gender, making one-sided rulings that only penalized him and not the mother, even though they both admitted to the same bad conduct, and making up facts and accusations about him that were not true and not testified to, then banning certain of his relatives from seeing the child based on these false facts. He claims that the judge gave Mom everything she asked for without any consideration of him. Dad says that the judge was fundamentally unfair to him, and he wants this judge to recuse the old judge, even though the trial is done and over. Will he get what he's asking for? Let's find out.
This is cause number DIGN-25000006, and this is out of the 250th District Court in Travis County, and we are here on a motion for recusal. Let me have announcement of counsel, please.
Keisha Montoya for the petitioner and the movement, David Morris, Your Honor. Good morning.
Good morning.
Michelle Locke on behalf of Heather Schaefer, who is present. We are ready to proceed, Your Honor.
Thank you. Let me first note that I believe Judge Liu has voluntarily recused himself, and that
we don't have Judge Liu in this case, Judge. We have Judge Iserloh, who is the one that handled this case. Judge Liu is not involved in this particular case of mine. He's others, but not this one.
Okay, so this is, I got the wrong motion then, I guess. Please state the judge's name again.
Judge Iserloh.
Sorry, Ms. Montoya, that's correct.
Judge Iserloh was the judge at trial, Your Honor.
All right. And the motion to recuse will be presented by Ms. Montoya?
Yes, Your Honor.
All right.
Yes.
All right. And so your motion is based on?
I'm gonna start with, obviously, it's a Rule 18 motion to recuse, and then I have case law that I sent to the court. And most of them are Fifth Circuit Court of Appeals cases that had just come out in November and even December of 25. Would you like me to read those on the record? Or do you just know that they're in your email?
I have them. Yes, I was provided them when you submitted them this morning.
Yes. Okay. So, what I had planned to do was just go through the recusal line by line. It's just easier that way. This is my client's sworn statements, and so I'm just going to go through it that way if that court is okay with that.
All right, go ahead.
Okay. And then I also sent the transcripts, which my client is basing a sworn statement off of. That's what he is relating. So it's in the amended, but if the court would like, I will direct the court to each piece of the transcript that he is using for examples in his recusal, Your Honor.
Yes, I would prefer that everything be on the record. So I would prefer that you refer to them as you are, or rather that you address them as you are referring to them.
Yes, Your Honor. Okay. My client is asserting that Judge Iserloh lacked impartiality and that she was biased throughout the trial. It was a 5-day trial. It didn't go to jury, but it was a bench. That she was biased and she lacked impartiality, not just with her ruling, but just throughout the entire case. He is arguing that his due process rights were violated, First Amendment rights were violated with injunctions, that there wasn't any evidence presented. He is asserting that there were facts that led to the ruling that the judge stated, but that did not exist.
Okay, I need to get some clarification. This is a motion to recuse. Am I understanding this correctly?
Yes, it is.
But you've already had the hearing.
Yes, we have, Your Honor. However, we didn't.
Your motion should always be filed before. And so why are you filing it now?
Because we didn't know that we didn't know that there was a bias or impartiality. We just were going through the trial, And it was like we're watching things happen in real time. But the biggest issue we have is we have a motion for new trial. And so our concern is it has to go back to Judge Iserloh to make a decision about the motion for a new trial. And that has to happen before the 30th of this month. So our concern is if the judge is biased, or she lacks impartiality, who's going to make a decision? It would be the judge that we have concerns about. So at the time where we're in trial and all of this is going on, and then post-trial, more incidents occur during the motion to enter order. So we're basing it on, we have a new trial motion, and if it were granted based upon the arguments that we've made, it would have to go back to the judge that we believe is not impartial, Your Honor. That's the concern.
And then the other thing is rulings throughout the trial are not a basis for a recusal. But so other than rulings,
I understand. There's a couple of cases there's rare instances where and it's extraordinary. And I understand that, Your Honor. And I explain that to my client. It is extraordinary but there are sometimes where you can base a recusal off of the ruling. It's extraordinary, but it is in the Fifth Circuit Court of Appeals opinions that I sent to the court. But it's not just based upon the rulings, Your Honor. I would not waste the court's time for simply just that. So let me go through and we'll just walk it.
All right, go ahead.
Okay. So the first, I'm going to refer to, it is page 43, line 21 of our exhibit number 5. It's the last day of trial. And that's in the transcript, Your Honor. The Judge Iserloh, I say came down from the bench and made a 15-20 minute kind of closing argument is what it seemed like. We didn't make closing arguments. And she made references to my client, Dad. Go ahead.
Is this in front of the jury?
No jury, Your Honor. Ended up going to bench. So it was just, okay. Yes. Go ahead. She had made references. She had talked about Peter Pan, the movie. And she had said that Dad was, he was on this island with the lost children. And that's actually in the transcripts. And that Mom is this civilizing influence, meaning Dad is not civilized. And that it was strange too, because it was like, why are you saying that? But anyway, she says that she goes on then to talk about how Mom is a career patent attorney. And she makes references to Dad like somehow he's just this, I don't know, savage on an island with the lost kids of Peter Pan. And she kept referring to that. And I understood she was, I don't know the mind of the judge, but when you look at it in its totality, I think you'll understand what Dad's concerns are, what the petitioner's concerns are. So that's the last day, that's on page 43. And she also then goes on to talk about, he brings a sponge and a bowl of water and puts it on her bench. And she is using the sponge to talk about water and vinegar and what children soak up. And then she decides that Dad needs to read some book from Oprah to help him, I don't know, find love for his ex or something. And she did say that. And that's on page 64 and 65 of our exhibit number 5.
Will you read that, please?
Yeah. I'm sorry, Your Honor.
Will you read that section, please?
Yes, Your Honor. So it's number 5 on page 3 of his statement. And it is the book recommendations from her personal library, Oprah Library, with a sponge paired with water filled with a bowl, using as a props of choice. She spoke of love and vinegar, quote unquote. That's on page 64, 65. And what children are soaking up. And then the water was splashing over the bench, and she was jabbing her finger at the screen and displaying some image that she also brought to court. And then she did say that her rulings were guiding interests, were not based upon feelings. And then she continued this lecture where she was yelling at my client that he needed to crack, quote unquote, his hard shell, my way or the highway ego. And this is quoted. It's on page 51, it's line 22, 23. While physically banging and hitting her fist on the bench, and she was literally spitting on the bench when she was saying this. That's line 58. That's page 58, line 5 of 6. And she also said that she's so sick of this blankety blank. This is what she said, blankety blank authoritarian state. I could spit. Maybe I will spit. And then tells my client that he needs to do, quote unquote, his own inner work, and ordering him to start figuring out some way to love this woman again. That's page 62, line 3, and page 62, line 5 through 6. And then she claimed that respondent, this is mom, was very moving, and she almost had her to tears. That's line 50, that's page 57, lines 11 through 12. The problem is mischaracterizations beyond that, but our point is when you're yelling and banging your fist, pointing your finger, saying dad's uncivilized, talking about he has a hard shell ego, he needs to get over and do inner work, and how mom is so moving, she almost had her to tears. I don't know how anybody couldn't find that biased. And
All right.
I don't know how anybody could find there was a lack of impartiality, but I'll continue, Your Honor, because I want you to see it in its totality. So that's what client, that's on number 5. And then, judge kept going on about authoritarian times and authoritarian state and increasingly authoritarian society, and that she had some mindset that she likened to my client, like somehow he had his fist in the air and he was anti-authority or something. I don't know where she got that. Anyways, that was on page 42, lines 24, page 58, lines 5 through 6, and page 54, lines 6. And this was on exhibit number 5. Okay. Then she stated that she had spoken to 2 other judges throughout the trial. The only one that I know the only 2 I know she spoke to would have been Judge Mozzie, who has a lot of family law experience, and that was at bench. And then she said she had spoken to Judge Arth, who had had the case several times. He had heard the temporary orders and other temporary orders hearings quite a bit over the years that the case had been proceeding. She had made reference that one of the judges wanted my client to go to jail. I don't know which judge was that, but that's in the transcripts. And then she made up facts that never came up at trial, Your Honor. I've been the petitioner's attorney since the beginning. I've been at every hearing. I haven't missed any. Judge said that my client had been abused as a child. That's in exhibit 5, page 49, lines 7 through 9, and that he had been abused by family members. And so she was ordering a permanent injunction with his father and his brother, the child's grandpa, and her uncle, based upon my client being sexually abused as a child. That didn't happen. That never happened. That never came up.
No evidence of that?
No, it never came up at any hearing ever. That never happened. And so now there's this, lifetime injunction for this child, right? At least till she's 18, to be away from her grandfather and her uncle when there was no evidence that was presented. It never happened. My client was not abused by anybody. I don't know. I don't even know where she got that. So, and that's in the transcripts. So now we have a permanent injunction. So she can't even associate with her grandfather or her uncle with no evidence based upon assaults of my client that never happened. Right. Then it was the day before the last day, and this is on page 2, number 4. And we had gone to bench because the court had wanted to appoint a case manager It was something I had not heard of, but she wanted to appoint a case manager. And apparently in the family code, you can't do that. You have to get an agreement to do it. But this was before we'd even finished testimony. And she'd stated that Dad's not going to like my ruling. She'd already made a decision about this case, and this is day before the last day. And I had to tell my client that the court was already making a ruling on this. Did he agree with the case manager? Because you have to get an agreement to do it. So I had to ask him. She said, go ask him. Let him know. So I did. And he didn't agree to that. But if you've already made a ruling, we don't even have testimony from the last day yet. How is that not biased or lack of impartiality? We haven't heard all of the evidence yet. And we're already talking about a case manager. So, and that is on his page. That's on his page. Oh, and she also said in court, it's on Exhibit 5, page 62, line 15 through 18, that she wanted to have the case manager be a man, because she states, I think it would be a good idea to have a male, if you could have a male manager, if possible, just because we got Dad here and Dad needs a man to talk to. She says, but that's my views. My client doesn't need a man to take him in hand. He's not a 5-year-old. Okay. He doesn't need a man in general. He's perfectly capable of listening to a woman tell him things. There's been female therapists for the kids. There's female teachers he talks to. I mean, in fact, I would say 90% of the professionals on this case are all females. So I don't know why he would need a man to take him in hand or tell him anything. It was an inappropriate statement. It was gender specific, and my client believes that there's a degree of bias or lack of impartiality when he needs to have a man talk to him and some man case manager. That is in the transcripts of the last day. And then after, we have a motion to enter, Your Honor, several months later. We had to go back in October. This is a July trial. So we have to wait for judge to be available. She's not available. And then we were all available on dates until October. So we go to the motion to enter because I had to file a motion to clarify because I just didn't understand what the judge intended with respect to the order that was drafted by opposing counsel. There were additional restrictions inside of this order, and they were not either pled or they weren't in the proposed disposition of issues. So we just needed clarification. Did the judge intend those things to be there? Because what the judge said is, I'm awarding everything Mom asked for. That was the ruling. Dad gets standard possession, and I'm awarding everything Mom asked for. That was the ruling. So we didn't know if that meant everything where, everything in the pleading, everything in the PDI, and there were things that were not in the PDI that were in the order. So we didn't know if that meant post-trial. We didn't know what that meant. What does everything mean? I think it's a fair question. So we go to the motion to enter, and I said, Your Honor, did you mean it? We go through the order, the additional portions of the order, and I'm like, did you mean this too when you said everything, Your Honor? And so it became where judge was hostile, and I was just asking for the why, because if there wasn't evidence presented at trial, what was the court's reasoning? What was the court's intent? And I had to tell her to stop yelling at me, and I had to tell her to de-escalate because she was so mad. And she finally just said, it's sua sponte. I'm ruling sua sponte. I'm adding these things in. I said, okay, I just need to know that it's you doing it, and it's not just Mom has a wish list and you're just doing what Mom wants you to do. There's some reasoning behind what you're doing, right? Because I just need to know. So that had come up, and that's in our Exhibit 6. That's the motion to enter. And then she also, the additional injunctions that she added were, Dad has an injunction with respect to drug use, but Mom had to be drug tested, and her brother had to be drug tested as well. And that was by Judge Arth at temporary orders. So there's this one-sided drug restriction, or, he can't have people around that may be using drugs, which is fine. I mean, there's nothing wrong with that, but it should be mutual since they were both drug tested, and that didn't happen. And in trial, Judge Iserloh had asked about drugs, and I said, Your Honor, they were both drug tested. Why are you just looking at dad? Like, what is this over here? And she looked surprised. And I said, they both had to be drug tested, Your Honor. They were both using drugs, and her brother had to be drug tested. And then she had made a comment about, and then it's in the transcripts where she talks about, well, it's not I'm going to say exactly what she said, because it was like, I felt it was profiling. I understand that he's an African American. He has an afro. He does wear colorful shirts. And she did make comments throughout about his clothing, his attire. His daughter had painted his fingernails green the night before we had gone to trial. She made a comment about that. She made comments that mom wears, these black suits with tortoiseshell glasses. She was very put together. And so she was making comments about the differences between them, but also what each other looked like and was wearing. And so I get that, he has an afro, but that doesn't necessarily mean that mom's not using drugs too, because she was. Yes, I know she's a patent attorney, but that has nothing to do with drug use. They both were alcohol tested as well, because there were facts at temporary orders that caused Judge Arth to be concerned. They both were also ordered psych evaluation as well, because Judge Arth felt that was necessary. So to only order certain things against dad when mom also had the same issues, to me, is biased. I mean, if you just look at the Fifth Circuit Court of Appeals opinions, it's not like speculative. The court talks about, Fifth Circuit Court of Appeals talks about speculation, and we can't speculate that people know each other or that they have in of court together, or that they might know each other in a casual setting or anything like that. That is speculative, but this is actually concrete when you're talking about what somebody looks like, what they're wearing. You make differences. You talk about what someone is uncivilized or civilized, or when you're talking about something specific as drug use that was on both sides of this case, and yet you only order an injunction against dad. So that's in our Exhibit 6, Your Honor. And that ended up being in the final order. And this is when I was asking to clarify if she meant everything mom asked for. How does that happen? So that's on page 5 of his motion, Your Honor. It's number 10. And then Judge had stated that she would have sent dad to jail if mom had asked for it. That's on page 613 of his sworn statement. And my client has concerns because there's never been any issues of family violence. There's never been any issues about whether dad is safe or not. In fact, when mom had originally asked that he not have any overnights until the child was 12 back in 21, Judge Arth did not order that. He gave him expanded standard. When she had asked for injunctions about drug, Judge Arth was neutral at that hearing. He was very across the board with everyone, because there wasn't any evidence that dad was unsafe for this child. And yet here she is saying again, Judge is like, well, if mom had asked, I might order no overnights, but, respondent didn't ask for that at trial this time. But there was no reason for my client not to have overnights with his daughter. There was never any indication that he was at risk all these years. We're talking about from 21 when I initially filed, Your Honor, to 25. Nothing, never family violence, no issues of danger or anything else. And yet she sat there and Judge said that she might have ordered, a step up. And that was on Exhibit 5, and it was page 60, lines 17 through 18. Judge Iserloh stated, if mom wanted another step up, if she had said days only, I would have given it to her. And then my client, he said, this is a direct threat of no overnights for the next 8 years. His daughter's 10. 8 years of no overnights on a final order? When there was never any, he has expanded standard now, but there was never any indication that he was a risk to his child at all. But if mom had asked for it, she'd have given it to him. That's what she stated, even if there wasn't evidence that proved it. So she did talk about, Judge Eisler did talk about, she had an unconventional family structure. I don't know all of what that meant, but again, I go back to simply because my client is African American and he has an afro does not mean that he's unconventional. He's an engineer. He builds skyscrapers and buildings. His IQ is obscene. He donates his time to at-risk youth. He's not some hippie, which is what she likened him to. He's not. He's actually very structured. But he is artistic. He has to be because he's an architect. But that doesn't mean he's that doesn't mean he's a savage or anything else. So the continued insinuations that he's childlike, that needs to be taken in hand by a man, versus, I don't know, me, all of us as women, is, I think he's saying that it is exactly what the lack of impartiality is about. Men can take care of children. Men are rational people. He can listen to someone without, having to worry about whether they're a male or a female or anything else. So his argument is that the court made rulings that were based upon her personal feelings or her animus towards him, just a sheer bias, because she is dealing with a respondent who is a patent attorney, and she is commenting on how she's dressing, and she thinks he's some hippie anti-authoritarian person, and he's not. And so he's not uncivilized. I'm not even sure where that characterization came from. And for her to just make up facts, it didn't happen ever. I still to this day do not know, Your Honor, where those facts came from, that he was assaulted. Mom was assaulted, that's true, but Dad was not. And how you have a permanent injunction against his family members, and her family members, her grandpa and her uncle cannot see her when it doesn't even exist? How is that not a lack of impartiality or bias? So while I know that we don't typically say that, based upon a ruling, people get grumpy about rulings, right? And that's understandable. But this isn't just him saying that she is biased or lacks, impartiality predicated on a ruling. The rulings were based on facts that didn't exist. They were based on mischaracterizations of my client. They were based upon profiling him. And so the ruling is predicated on certain things that didn't exist. That's the issue that he has. Telling him that he has to start figuring out some way to love this woman again. There's no reason to say things like that. There's no place for that. He doesn't have to love her at all. He has to love his child. Okay. He just has to co-parent with her. So the clothing was just, so I think anytime that you mention what people are wearing, or you mention their style, or you mention just the physical attributes of somebody, that's bias. What does it matter that he wears colorful clothing every day to court, she said? What does it matter that his daughter painted his fingernails? I think they were green at the time. What does it matter that she's wearing a suit and tortoiseshell glasses? What do those things matter when you're talking about custody? Do you need, Your Honor, a client to testify, or I'm not really sure if you want him to testify or not. These are his statements. So
I think we should get some evidence on the record. And were you going to admit your exhibits that you made reference to?
Yes, Your Honor, if the court would allow. Yes. Did you want me to call him, Your Honor, or do you?
Well, just a minute. You made reference to a lot of exhibits.
Sure.
Okay, so if you're going to offer them, I think you should, because I have not received anything.
Oh, do you have them physically, Your Honor? We e-filed with all of them, but we could send them also. I'm going to put them on a stand to get them, but I just want to make sure you have like physical. We don't have a box this time. Usually we have a box and we didn't have one, so I didn't know.
Okay. Mr. LaRue?
Yes,
Are you
Judge.
there? Okay. I guess the motion that I received was not for this hearing that we're having right now. I need to have whatever it is that they did file, and I need to clarify the style of the case that I called. So I think we need to address that first. Would you send that to me now, to the email?
Yes, Judge. Give me 1 minute. I'll pull it from the file and send it over to you.
All right, thank you. All right, I haven't received it yet, so let's go ahead and proceed so we don't delay. I need for you to raise your right hand, Mr. Morris, please. Do you solemnly swear the testimony you'll give here today to be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, go ahead, Ms. Montoya.
Yes, Your Honor. My paralegal wants to know, did you want us to email you the amended that has all the transcripts? We can shoot it to you now.
All right.
If that helps.
Yes, go ahead.
Send that to LaRue, to Mr. LaRue, Your Honor. To send it to Mr. LaRue, or do you have an email you prefer?
Yeah, go ahead and send it to Mr. LaRue.
Okay, Your Honor, it's on it. Thank you. Okay. Mr. Morris, can you hear me?
Yes.
Okay, fine. I'm just going to walk through your recuse, what you swore to, okay?
Okay.
All right, yes. Do you recall, well, can you please describe in your words the trial, how it went? Let's start with day one and go from there, if that's where you want to start. Or would you like to, would you like to describe to Her Honor the last day?
Yeah, I believe the last day was pretty indicative of the entire case or hearing.
Do you recall how Judge Isolo characterized you?
Yes.
Your Honor, I'm sorry, not to interrupt his testimony. We did send it. It's in your box in the email.
Thank you. I've got it.
Okay, Mr. Morris, can you please describe how the court how Judge Isolo had characterized you, please?
You froze.
Oh no. No. Am I back?
Sorry. Okay. Yes, you're back. Go ahead.
Okay. Mr. Morris, can you describe how the court had characterized you, please?
Yes. She made multiple references to me being Peter Pan-like or childish. It appeared she negated kind of any of my professional capabilities as an engineer who owns his own consulting firm for the past 20 years. She, as mentioned in my affidavit, she made references to, my drug use and my drug use alone. She made comments on her clothes and how mom was dressed a certain way and how she was a civilizing influence on the child, despite the fact that the judge had previously mentioned, the fantastic time and opportunities that I spend and provide with our child, and that she is in part as amazing as she is because of those influences.
Do you recall when she said that mom was the civilizing influence, or that she was the civilizing parent?
Yes, that was on day 5 during the judge's, we didn't have neither party was given the opportunity for closing statements, and then the judge came out and gave a 25-minute speech, I guess, that berated me multiple times. She was continually yelling at me to crack, crack, crack my hard-shelled ego. She was banging her fist on the bench. She brought out a bowl of water and sponge and was using that as an example of how our daughter was perceiving life, and she was splashing the water all over the place while doing so.
Are these, I don't want to interrupt, but are these statements that you're saying that the judge made, are these in the transcripts that we have provided to the court?
They're in the day 5 transcripts.
Okay, and they're also in our amended pleading, correct?
That is correct.
That you're referring to, correct?
Yes.
Okay, Your Honor, I would like to publish the transcripts for that day.
Go ahead.
Can I continue, Your Honor?
Yes, ma'am, you may.
Thank you. Thank you. I'm sorry to interrupt, Mr. Morris. You were talking about the sponge. Is there anything else about her characterizing you versus the respondent?
Yeah, she just flat out made up the fact that I had been molested as a child. That first off never happened. Second off, never even got discussed in any of our hearings over the past 4 years, and specifically never in the 4 or 5 days of our final order hearing.
Did you hear when I had said that she said that you needed to do inner work? Do you recall that statement?
Yes, she claimed that I needed to do the inner work to process this trauma that had never happened. And that mom had done inner work, but that I had not.
Okay. And did you hear when I was reading this authoritarian, when she would mention this authoritarian state that she has disdain for, or she doesn't like? Do you recall what that was about?
Yeah, she had said, that she was in line with me on, not wanting to label children, not having people, tell you what music you can listen to or what actions and activities you can do with your child. She said she was so sick of this authoritarian state that she could spit. Maybe I will spit. And then she literally spit on the ground while she was on the bench.
And that's in the transcripts that we provided.
That is.
Okay, and that's exhibit number 5, correct?
Yeah, yes, I believe so.
Okay. And do you recall that that Judge Iserloh wanted to have a man
Yes.
over you or over the case? Do you recall what that was about?
I know she had mentioned it off bench or at bench, and then again later in her 25-minute ruling that she gave, that she said she thinks that I should have a man or a male to talk to. I'm not really sure why.
Was there did you hear when I was talking about the yelling and the just the judge's conduct throughout trial? Do you recall that?
Yeah, she was. There were a couple times during her closing statements where when she was saying to crack, crack, crack my hard shell ego, she was yelling, she was banging on the bench. She said, this work needs to happen and you need to fix your ego. And then she was yelling, it's like, do you hear me, Dad? Do you hear me, Dad? Just yelling directly at me.
Were there other times that she was yelling throughout the trial?
There were during testimonies and cross-examination. She was yelling at you as counsel. And then again in the October 16th motion to enter, she was yelling. And I recall that you had asked her to stop yelling or asked her why she was yelling. And I believe that one was with respect to the sua sponte, where she had ordered a psych eval that wasn't in the PDI.
Do you, I'm going to direct you, we have Exhibit 2, and it's page 74 of Exhibit 2. And do you recall, you said that I asked her, why are you yelling? Do you remember that?
Yes.
Okay, Your Honor, I would like to admit Exhibit 2. It's specific to page 74.
All right, it's received.
Thank you, Your Honor. Do you recall where I had stated to the court that I was being attacked and I didn't know I don't need to be attacked? Do you remember that?
Yes.
Okay. And do you remember what I was being attacked about?
The judge had said that you had misled the court, this court and prior courts, with respect to facts of the case.
Do you remember which one? Do you
Which
remember
facts?
Go ahead.
Oh, she said Judge Arth specifically.
Right. And what was it that she said that I misled Judge Arth about? Was Judge Arth even present during the hearing, the trial?
No, he was not.
Okay. So do you remember that she apologized for attacking me?
She did apologize, yes.
But do you recall where I said it was abusive, that she was being abusive?
Yes.
Okay. And that is in our exhibit number 3 on page 81 and 82, correct?
Correct. Yeah.
Do you recall that?
I do recall that.
Your Honor, I would like to publish exhibit number 3.
All right, go ahead.
Thank you, Your Honor. Did we produce evidence do you remember what the whole issue was about? That we had to go produce evidence that not only did we not mislead the court, we had proof. Do you recall?
Yes, it was about Heather not wanting me to have interaction with the child unless it was supervised. And this was in September of 2021, before our temporary orders hearing, which was in October of 2021. So Heather had sent an email to me that said, we can talk about your time with Cameron in a supervised location.
Right. So she was denying you access unless it was supervised, right, before the hearing, correct?
Correct.
Is that why you hired me?
Yes.
Okay. And then did we produce evidence that she was denying access unless it was supervised to Judge Iserloh?
Yeah, we tried. We on a lunch break, we found the email that Heather had sent me, and Heather had also provided that during the supplementals, and had also provided it to additional professionals throughout the case, and we found that email.
One of the professionals she provided to was the person who did the psych eval, was Michelle Munivar, correct?
That's correct.
And that was in the record, correct?
That's correct.
Right. It was a part of, I believe, respondents' exhibits, right?
Yes.
Right. But did the court allow us to enter into evidence in our defense that you were being denied access all the way back to 21?
No, she did not allow us to enter into evidence. She said something about it not being bait stamped for this trial, even though respondent had, or Heather and her counsel had already produced that both to us and to Ms. Munavar.
Do you recall the statements Judge Iserloh had made about appeals, about between the two law offices? Do you recall that?
I do.
Can you please state to the court the statement that Judge Iserloh had made?
She, from what I recall, at least two instances where she made a statement that opposing counsel had a case on appeal based on due process, and that also opposing counsel, and then separately also that opposing counsel had the money and the financial means to pursue in any appeal in a, with a better outcome than our appeal.
Okay, I need you to be a little bit more clear about that so the judge understands the context of what was being said.
We had, opposing counsel had taken and offered as evidence a testimony, a deposition from Michelle Munavar, and they had taken that deposition past discovery period without good cause or any order to do so. And so the judge allowed that into evidence. And so we took issue with that. And so judge felt that we would appeal in part because of that reason. And then so when the judge would make comparisons towards an appeal, she would reference, our issue with the deposition being allowed as evidence, which was then used, in the gross mischaracterization against me by the judge. So she would make that comparison versus Heather's counsel's opportunity to appeal based on these other reasons, one being due process and the other being just the fact that her firm has the means to pursue this appeal financially.
Okay, and that is actually in our Exhibit 1. That's from the first day, correct?
Yes, the discussions of our objections to the deposition being admitted to evidence is day 1. And I don't recall if it was day 1 or day 2 or both where the judge made the reference to opposing counsel's appeals.
Okay, but those would be Exhibit 1 and Exhibit 2.
That's correct.
Your Honor, I would like to enter those I'd like to publish those, please.
Now, when you say you want to publish them, does that mean you're going to pull them up on the screen so I can see them? Because there's no jury here.
I'm sorry, Your Honor. I'd like them to be entered into evidence. I'm sorry.
Okay, and that was Exhibit what?
It's Exhibit 1, Your Honor, of the transcript, and Exhibit 2, Your Honor.
And it is the transcript.
Yes, Your Honor. Everything that he is referencing in his is only court transcripts, Your Honor. It is nothing else. It's just the trial and the motion to enter, Your Honor.
All right. They're received.
Do you recall what the court ordered you when she said that she was going to give everything Mom asked for? What did that include with respect to attorney's fees?
That's part of what we had to clarify in October, but it included a list of, I think it was $120,000 worth of pre-sanctions should I pursue an appeal. And then it also included about $250,000 of her attorney's fees from what I understand, for over the entirety of the past 4 years, from October 2021 until July 2025. So the entirety of her attorney's fees.
Even the attorney's fees that, if you recall from hearings where the court denied her request, correct?
Yes, I believe it was all her attorney. Yeah.
It included the attorney's fees, the TRO that another judge vacated, correct?
That's correct.
Do you recall that you had mentioned earlier about the drug use and that there's this injunction imposed only against you versus against respondent mom. Do you recall that?
Yes.
Okay. Do you recall when that injunction was actually added to the order or when it was ordered?
I believe it was added in October when we entered the final order.
Okay. And do you recall what Judge had said about that?
Yeah, she specifically said that, as the judge quoting, like, I don't recall much about it, but I do remember there were discussions about her brother using and discussions about, dad having issues with people who are around him using drugs.
Do you recall who she was talking about?
Mm,
This is Exhibit
no,
6. So, and it's in your in your statement where you are talking about she didn't remember much about the drugs with respect to mom, other than there was an issue of influence of drugs for some people that you knew, right?
that's right. No, she did not mention anybody specific.
Okay. Do you recall what the issue we were clarifying was and why? Do you understand what I'm asking?
Yeah, the issue was that it was a unilateral injunction against me and me alone for having kid around anybody using drugs when in both prior hearings and this hearing, Heather testified to also using drugs with me. And, her brother had also testified to using drugs. So it was odd that, I have an injunction, but, Heather is allowed to have child around people who are using drugs, apparently.
Was there any testimony, any of the prior hearings or in this hearing that you were associating with other people who were using drugs around your child other than mom and her brother?
No, not especially not in this hearing.
But there's now injunctions, right, on your side of this case now, right?
That's right.
And none on hers, correct?
That's correct.
Even though there is testimony their brother could still be using, right, back to temporary orders with Judge Arth, correct?
Yes.
Okay. All right. So, Your Honor, that's exhibit that actually happened at the motion to enter. That's Exhibit 6. I don't know if I've asked that it be entered into evidence, but if I did, can I please have it entered?
Yes, it's received.
Thank you, Your Honor. Can you, Mr. Morris, please conclude describing what you consider to be the lack of impartiality from the court, from Judge Iserman.
Yeah, just based on, the multiple references made to the physical differences between myself and Heather, the threats of, putting me in jail based on apparently an enforcement, my first enforcement charge, and also enforcements that, we didn't have the opportunity to counter or refute. So all the enforcements were just accepted wholeheartedly as truth by the judge. The threats of, no overnights for the next 8 years of our daughter's life when, there had been no evidence, no cause over the past 4 years of our expanded standard, or over the entirety of her life to now reduce reduced to no overnights simply only if mom had asked. That doesn't ring uh impartial to me. If there's a threat of no overnights, then it shouldn't be whether mom had wanted it or not. It should be based on facts and not feelings. Um, the fact that she just made up out of thin air that I was molested. Um, the yelling at the bench during her closing argument when nobody had an opportunity to give one, but she took her time to denigrate me during it. Out of, and then I mean everything else in our affidavit or our pleadings, I guess. I'm not sure the right word.
Do you recall where you talk about this injunction with your pocket knife? Do you recall that?
Yes.
Oh, okay. Can you please tell this court about this new injunction?
Yes, so there is now an injunction on me carrying a pocket knife that was added. It wasn't in there. It wasn't in their PDI. It was discussed during trial, but she added it in October that I cannot have a pocket knife that I've carried for over 3 decades. I cannot have a pocket knife around Heather.
And did any other judge that touched this case ever order that injunction?
No, and they specifically did not. We had a TRO with Judge Hexel Cantu, and she specifically said she's not going to order that injunction.
Is there any other instances of bias that you would like this court to know?
I guess in conjunction with the pocket knife and the injunctions, there's an injunction on me having child on a motorcycle, which is a legal activity that I can do, and also injunctions on devices or toys that I can, or activities that I can participate in with my daughter that are, legally age appropriate.
What do you mean? Can you please tell this court what you mean by toys?
Yeah, so there is a one-wheel device that Cameron, our daughter, had learned how to ride some years ago, and that we were using often around the neighborhood, with the proper gear and helmets and stuff. And then that device also has a governor that you can set to limit the speeds and the functionality of it. And, she she really enjoyed being on that thing, and we had two of them, and we'd ride around the neighborhood and pick up trash. And Heather got an injunction. She went to the court and got an injunction on that device specifically.
On what basis? What does she base her request on?
She said that she didn't like it, and then she also said that based on the manufacturer's recommended age, um, but when you go to the manufacturer's website and you look at this device, they have, the staff and the people who make this, they all have their kids right in this thing. YouTube and social media are just smattered with all ages using this device, and it was a great level of confidence building for Cameron. She taught multiple of her friends how to ride and how to use it, and then it was just taken away.
And then the motorcycle, there's nothing illegal for you having your daughter on a motorcycle, correct?
That's correct.
There's no state law that says you can't do that, correct?
That's correct.
And there was testimony that you're actually, but she had been on it since she was very little, correct?
Yeah, a different version. We had been on smaller motorcycles and dirt bikes on the properties. There was, when we lived together, Heather was on half an acre. Our neighbor had an acre. Our other neighbor had an acre. All three of us rode motorcycles for most of our lives, and so there were many smaller bikes to choose from, and we would ride around the yard, and we had been doing that for some years.
Was there evidence that wasn't there evidence that a CPS report had been filed because of the motorcycle?
Yes, a CPS report had been filed, and the motorcycle was mentioned in it.
That was dismissed, correct?
Yes.
Okay. And was there any evidence presented that Cameron was in danger of being on your motorcycle at all?
No.
And yet, at the motion to enter, it's there, this injunction, till she's 18, correct?
Correct. Yeah, I forget the exact age. It might be 12 or 14, but that injunction is there.
It's there, right? But it wasn't, there wasn't evidence presented there was a danger, correct, in court?
That's correct.
Your daughter can no longer talk to her grandfather and see him, right?
I believe, yeah, the injunction is that she cannot be left unsupervised with my grandpa or my uncle.
So she has to constantly have somebody with them, right? When she's with them, or no? Do you know? Do you remember it exactly?
I can look, but I believe it's shall not be left unattended, unsupervised in the presence of my grandpa and my brother.
And how long is that injunction?
I don't know if it has an exact year. I mean, at least until she's 18, I presume, until the final orders lapse.
Was there any evidence presented at trial that your grandfather or your uncle were a danger to Cameron?
No.
And that was that added at the motion to enter, or was that at the ruling, the trial?
I believe that was in their original PDI, so I think it was carried over from when the judge said everything they wanted. I believe it was in their PDI.
When the judge ruled that she's going to give them everything that they wanted or everything they asked for, let's make sure we get whatever it is correct. Did you consider that to lack impartiality or be biased?
Yes. Yeah, absolutely.
Okay. I'm just asking you what you consider to be impartial or biased. Okay. I'm not telling you, I'm asking you. Okay.
Yes, I mean, I feel there was, I mean, we were there for 4.5 days, and I feel to give a blanketed, unclear, everything they wanted ruling just completely negates like any part of my testimony, any part of my parental involvement with the child since birth. Um, just it specifically negates the last 4 years of expanded standard.
Did you even know what everything that they want meant?
No.
Your Honor, I'm going to pass the witness, please.
All right. Miss Locke, were you going to question the witness?
I am, Judge. I just didn't know because we've been going for a little bit if we needed to give the court reporter a break or if anyone needed a break, but I'm ready to proceed if the court is.
Oh, okay, let me just check. Thank you for pointing it out. Miss Goodman, do you need to take a 15-minute break?
I'm good. We can
All
keep
right.
going. Thank you.
Please let me know if that moment does arise.
Okay, I will.
Thank you. Go ahead, Miss Locke.
Thank you, Judge. Mr. Morris, the court rendered its rulings back in July of 2025 on this case. Is that correct?
That's correct.
All right. And you did not file your motion to recuse the judge until November 13th of 2025. Is that correct?
We filed our motion to recuse after the final order was entered, correct?
Correct. But you received at the hearing in July, at the conclusion of the trial, the court said as follows: Ms. Locke, your proposed disposition of issues is granted, correct?
She said she was granting you what you asked for.
Well, she actually said, and the court has the transcripts, she said, Ms. Locke, your proposed disposition of issues is granted. Isn't that correct, Mr. Morris?
Okay, I'd have to see the transcript.
All right. And Judge, I'm going to, if I have permission to share my screen, I would ask the court to take judicial notice of the disposition of issues that were filed in this case. Now, let me pull them up. They were filed with the clerk's office on June 23rd of 2025. And I'd like to introduce them into evidence as, I guess, respondents one. I'll have to mark them and send them to the court, Judge. I'm operating on skeleton crew today because my office is closed for the holidays, but I will get it to the court. So it's respondents one is the proposed disposition of issues that are already on file with the court as of June 23rd, 2025.
All right, it's received.
Let me share my screen. If my window will open. I'm sorry, Judge, it's just slow this morning.
Okay.
And so, Mr. Morris, when the court granted the proposed disposition of issues, you had already received these proposed disposition of issues from Ms. Schaefer. Is that correct?
Yes.
Okay. And it was 9 pages of very specific request. Is that right?
If that's the page count, yeah.
Okay. And in there, she lays out all of her specific requests that the court granted, correct?
Okay.
Was that correct? Not K. I need a yes or no, Mr. Morris.
Yes.
And you were ordered to pay child support, correct?
Yes, I had been. Yes.
All right. And my client asked for exclusive rights and duties, and she was given exclusive rights and duties, correct?
Correct.
And my client asked for no more than a standard possession order, correct?
Correct.
Okay. And that is in fact what the court ordered you, a standard possession order, correct?
Yes.
And we had some specific requests regarding telephonic and video access, correct?
Correct.
All right. And we also asked for, because Judge Arth had ordered a parenting coordinator in this case, we'd asked for a parenting facilitator. Is that correct?
That's correct.
All right. And so this discussion about at the bench with regards to a case coordinator or case manager was in relation to the request that my client specifically had with regards to a parenting coordinator or parenting facilitator. Isn't that correct?
I don't know your discussions at the bench.
Okay. And there were specific travel provisions, correct?
Yes.
And those specific travel provisions were actually put in place by Judge Arth as it related to out-of-state travel, correct?
Correct. And they had been adhered to.
And they were, well, let's be clear, the court found you in contempt for violating notification provisions and violating possession or access, didn't the court?
No, are you talking about travel? No.
Okay. Did the court find you in contempt for at least 34 different violations, Mr. Morris?
I believe that was with respect to enforcements, and that was what we mentioned about due process and me not having an ability to counter those. They were just accepted.
Okay, well, you had 5 days of trial, correct?
We didn't.
And you were able to testify, correct?
We didn't.
And your attorney, Ms. Montoya, got into multiple heated discussions with the court. Isn't that correct during the trial?
Yeah, there were discussions.
And in fact, wasn't at one point the threat from Judge Iserloh that Ms. Montoya was going to be held in contempt if she didn't stop raising her voice at the court during the motion to enter hearing?
I don't recall why it was, but there was a threat of being held in contempt.
Okay. All right. And in fact, there was a request from placing the permanent injunction relates to placing the child on a moving motorcycle until she's 12 years of age, correct?
That's correct.
And then there was a specific request as related to leaving the child alone or unsupervised with the following individuals, correct?
I see that, yes.
Okay. And we also had a request to prohibit a counter-respondent, which was you, from allowing individuals who are known to be under the influence of illegal drugs near the child, correct?
Yes, only for me, correct.
Okay. And then, all right. And then we also request that you be prohibited from placing the child on a motorized device as not designated by the manufacturer as a motorized device for a child, the age of the child at the time of use, correct?
Yes.
All right. Now, these actual restrictions were previously put into place by Judge Arth, correct?
No.
You're telling this court?
Judge Arth did not issue an injunctions on my father or brother.
Okay. But
Judge Arth also, in the temporary orders, it was a mutual injunction on the drugs because of prior testimony. And Judge Arth only limited item D on the screen to a specific device that you guys brought up.
Correct. But Judge Arth also did a restriction on the motorcycle, correct?
He did. And if you look at the transcripts, he said that it was a temporary injunction during the pendency of litigation and that it's not illegal, but because mom was heated about the topic, that he wanted it off the table temporarily.
Okay. But we requested that injunction continue, correct?
Correct.
All right. And then Judge Arth is also the one that issued the injunction on placing the child on a motorized device as not designated by the manufacturer as a motorized device for a child at the time of the age of use. And that related specifically to the one wheel that you were putting the child on when she was how old, Mr. Morris?
6 or 7 or 8. I'd have to look back.
Okay. And the manufacturer guidelines that we brought up said the child should not be placed on that device until they're 12 or older, correct?
There was a recommendation.
Okay. And Judge Arth actually made a commentary to you at that additional hearing on that injunction relating to your constant need to create problems with Ms. Schaefer by putting the child on devices that were not necessarily appropriate and you knew would cause Ms. Schaefer heartache, correct?
No, he mentioned, this being a hill, but not the words you just said.
Okay. And let's go to you remember there was a garden ad litem in this case, right?
No, there was not.
I'm sorry. That's correct. We had a Michelle Munivar do psychological evaluations and did a contested custody evaluation. Is that correct?
No, I don't believe she opined on custody. Hers was a forensic psych eval.
Okay. And in the actual psychological report that was introduced into evidence, there was admission by you of you having inappropriate sexual relations with your sister when she was a child and you were a teenager, correct?
Yes, over 30 years ago.
Okay. And there was a temporary orders hearing. My client had testified uncontroverted that you had told her that your dad and brother had molested minor children. Do you recall that?
No, I did not say
Okay.
that as a fact.
Okay, but you did tell that to my client, correct?
No. If you can
And
repeat
you, in fact,
if you
told
can
my
repeat the
client.
wording.
I'm sorry, what wording did you use when you told Ms. Schaefer that your dad and brother had potentially molested minors?
I never said anything about my father.
Okay, what about your brother then?
I said that there were allegations.
Okay. And that testimony was at temporary orders from Ms. Schaefer, correct?
In part.
Okay. And in fact, part of that was addressed with Ms. Munivar, correct?
Well, all of it was addressed with Arth, Miss Munivar, the parenting coordinator that we had, Miss Shar Wittenberg. Judge Arth had heard that since day 1 and 2 of temporary orders back in 2021 and found no cause, no evidence presented to put any injunctions on any family members. He specifically said it, and which is why it was not in the TOs.
Well, you don't know why Judge Arth made the rulings. You don't know into his brain when he made the rulings, correct?
He specifically said, I'm not doing that.
Okay. And then but he did not have the benefit of that time of your psychological evaluation from Ms. Munivar, correct?
I don't know what benefit. No, there was no new evidence in that that surfaced from her psych eval. He had all the information.
Judge, I would move to introduce what I'm going to mark as R2, which is the psychological evaluations.
All right, go ahead.
Your Honor, I'm just going to object, just nothing else for the record, because this was a big point of contention that Michelle Munivar was not available for trial. I guess she was having a baby and we were not able to depose. And my client did state that I had filed a continuance, in fact, over this because her testimony was coming in. So I just want to object now because I'd objected before. That's all.
Yes, but it was considered by the court, obviously, if it did come in.
Correct.
Yeah, we did. We had a thing. I'm just raising it again, Your Honor. That's all.
So the record is clear, Judge. There was a hearing on the motion to exclude the psych evals and a motion to exclude Michelle Munivar's deposition video testimony from trial, based on, we noticed the lots of scheduling issues. The psych evals came out much later than anyone anticipated. but after all of the arguments and all of the discussions between Ms. Montoya, myself, and the judge overruled their objections and allowed both the video deposition of Ms. Munivar in addition to the psychological evaluations.
I agree to some of that, so I'm not going to, but we didn't actually have a hearing on it. It was started off as a motion to eliminate because we thought we were going to go to jury, and then we ended up going to bench. So the court did listen to our arguments because we filed motions to exclude, like we didn't get them until the night before trial. We actually didn't. We didn't get it.
Let me be clear that the rulings of the court, whether they are favorable or unfavorable to any party, cannot be the basis of a motion to recuse. And I know that your position is that she demonstrated behavior that may not be judicial, but the fact that she had this evidence, and that's where Ms. Locke is going, the evidence was available to the court to consider, whereas you were positioning it as the court didn't have any basis to do what they did, and that would be more for an appeal, not for a motion to recuse. So I think Ms. Locke is simply trying to establish that there was some evidence, but you're objecting to it now is irrelevant. Go ahead.
I understand. I just want to make sure that I have a good record. I just want to make sure that I say it again, just so that we all know that I was making the argument originally, Your Honor. That's all.
But this is not an appeal, so go ahead, Ms. Locke.
Thank you, Judge. I'm going to share, I guess what's been admitted is R2. And I'll go to the top, but this is actually, so we're on the same page, Mr. Morris. This is the forensic psychological evaluation that was introduced at trial, that was done by Ms. Munivar, correct?
It's still loading. There it is. Yes, from September.
All right. And she was to answer in her psych eval, and this is what she answered in her psychological evaluation that was 30 pages. Are there any mental health concerns, diagnoses, or behavior patterns that might hinder or negatively impact either parent's ability to co-parent and or in the parenting role, correct?
Yes.
All right. And this entirety of these 30 pages were introduced into evidence at the trial, correct?
That's correct.
All right, let's go to page 5. And in the report, it actually talks about, in addition to the footnotes, it talks about the one wheel, right? Because there was a one wheel accident that became the subject of dispute between the parties, correct? And you'll see here on the bottom, details surrounding the one wheel accident.
Yeah, there was, the one wheel was mentioned.
Okay. And there was also details surrounding CJ's riding Mr. Morris's motorcycle and details surrounding the inappropriate sexual incidences between Mr. Morris and a younger sibling, correct?
Yes, that was all previously discussed. Right.
And all of this touched upon, according to Ms. Munivar, the topic of safety and judgment of you, Mr. Morris, correct?
I mean, that's a sentence. I can't say what she said.
Let's see. And see, she actually discusses in her footnotes the whole one wheel incident, right? The same thing the Judge Iserloh, issued an injunction on relating to manufacturer recommended guidelines for use of devices, correct?
No, I don't know about discuss the entire incident. What it says right there is I denied an accident occurred. Rather, there was a fall and scraped elbows.
Okay. But there was a discussion about the one wheel. There was a discussion about lack of safety precautions, discussions of the one wheel manual, which stated it was not recommended for children CJ's age, and only one person should ride and not multiple.
No,
There
it
was a
says
discussion and evidence before the court that related to the one wheel and manufacturer's guidelines for devices, correct?
no, it says Ms. Schaefer reported her concerns, lack of safety precautions. That's what it's saying.
There was also extensive discussion in the psychological report about the travel dates and travel exchange issues that you had with Miss Schaefer. Is that correct? If you look at the notes, starting with note 8.
Yeah, there were discussions where I would provide the detail required per temporary orders.
Okay, and do you see on or footnote 10 where it says this is an example of a form of gaslighting behavior by Mr. Morris? Do you see that?
I see that.
And where Ms. Munivar continues to say gaslighting is a form of manipulation where a victim of such behaviors will question their own memory, sanity, or even reality, all of which creates confusion and doubt in the self, which can be a coercive and controlling tactic. Do you see that?
I see that she wrote that.
Okay. And so she actually identifies some of your behavior as gaslighting, where she says Mr. Morris then pushes back and describes Miss Schaefer's behaviors to be unreasonable, manipulative, or controlling, right?
Yeah, I do see that. And
Okay.
that's also part of our reason for biased against Miss Munivar.
Well, and the truth is you just don't like the rulings because you lost, correct?
No,
I mean, you didn't get anything you requested. Isn't that correct?
I don't know how to answer that.
Okay, well, tell me the one piece of relief that you requested from Judge Iserloh that Judge Iserloh granted.
Well, she granted Heather's, so she didn't grant mine.
Okay, so you did not have the court grant any relief that you requested, correct?
That's correct. I
All
believe
right.
based on bias to blanketly disregard the entirety of my testimony and facts and make up facts against me. Yeah,
Okay, and so let's talk about that. So your belief is she disregarded the evidence you put in when she made her decisions. Is that correct?
that's correct.
All right. And so you believe that the judge looked at your evidence and said, I'm just going to disregard it.
That's correct. She made statements that I would bring child home tired on a Sunday night. She made statements that I would take the child out of school early to start my possession, which was not true. The time that happened was before temporary orders, and it happened on both our parts. So it was over 4 years ago. And in her closing arguments, she made statements as if it were true and happening today, and is not. So yeah,
Okay.
that's disregarded
But
amongst
it's
other
true
things.
that you did do that, and there was evidence before the court that you had taken her out of school early for one of your trips, correct?
For one of my trips, yes, but prior to any temporary orders.
Okay. So there was evidence before the court on that particular issue.
From over 4 years ago, sure.
Okay.
Not currently today.
And Judge, I'm going to move to introduce what's going to be labeled as R3, which is the order of enforcement by contempt.
Go ahead. It'll be received.
Thank you. And I'll share my screen, Your Honor. So I'm still sharing. Give it a second. So let's go back to your statement a minute ago, Mr. Morris, where you said you testified and the court disregarded your testimony. Do you recall that?
Yes.
All right. So it is actually your belief that you provided the judge for all the reasons that you should not have been held in contempt, correct?
I guess piecemeal throughout, but not specifically, no. These were provided, I believe, the last day or end of day 4 to the court.
What do you mean provided to? I'm not sure I
That's
know what you
when
mean by that.
that's when you discussed with uh, Heather on the stand these enforcements.
Okay. And the enforcements were set for final trial at the same time as the jury trial, correct?
Correct.
Okay. And in fact, our proposed disposition of issues addressed not only the requests on the petitions to modify, but the request on the contempt in the same document, correct?
Correct.
All right. So the court found you of guilty of separate violations of the temporary orders that were rendered on October 1st, 2021, correct?
That's what this document says.
Okay. And the
Where's
court
it? What date
finds
is
the
this
guilt.
document? I'm sorry.
This is the order of enforcement by contempt that was signed by the court on or about October 16th, 2025.
Okay, thank you.
And it says, just so the record's clear, that you appeared physically in the courtroom and your attorney of record appeared physically in the courtroom and announced ready, correct?
Correct.
All right. And you were found guilty of further violations of the temporary orders that were rendered on March 2nd, 2023. Is that correct?
That's what this says, yes.
And you were also found in contempt for violations of further temporary orders that were rendered on April 29th, 2024, correct?
That is what this says, correct.
All right. And so let's go through what the court found evidence of in the on the contempt. It was that you failed to log in the child for Zoom calls. And there were issues with regards to you providing access to my client during your periods of possession as ordered in previous orders, correct?
Correct. Yeah, I mean, that's kind of what we take issue with.
Well, tell me this. You take issue with it because you don't agree that the court found you in contempt? Or do you take issue because there wasn't evidence to support it?
No, because it says the respondent did not make the child available. The child was available through various means.
Okay, so you are upset with the court's rulings because you don't believe the court followed the evidence as the legal arguments you're making with the child was actually available, right?
Yeah, and some of it was with the court was presented with respect to travel notification. The court was presented with the notification that I gave, which indicated the date in the city and the times of overnight. But it was presented as that I violated some rule, and I didn't. The further temporary orders, I provided all the information required.
Okay. And you actually on this, you would agree with me that at trial you admitted that Cameron did not talk to her mom on these events, but rather you made her available under some technicality, and that's why you shouldn't be held in contempt, right?
And not all of them, but some of them she did talk to, yet they were still listed as violations.
And so your argument on these solely relate to the evidence, right?
Correct. Some evidence which was presented and ignored.
Okay. And that was, let's see, how many violations for contact? It was 26 violations over a period of 3 years during your periods of possession. Does that look about correct that the court found you in contempt for?
That looks about correct. You can see two are of
Okay.
the same date. So
Then there was an issue with regards to failing to inform Ms. Schaefer in a timely manner of significant information concerning the health, education, and welfare of the child. And specifically, there was medical care that you obtained out of state, correct?
I provided that information.
Okay.
Is
But your argument is the court disregarded what you provided and still held you in contempt, correct?
well, I did provide her that information.
So the answer to my question is then, did the court simply just ignore your evidence?
Either my evidence or testimony.
Okay. Then there was additional violations relating to weekend possession, and those were 3 separate violations for summers of 2023, 2024, and 2025. Is that correct?
That's correct.
All right. Now, let's talk a little about the jail time. Ms. Montoya kept making reference to the judge threatening to throw you in jail. Wasn't her, if the court looks at the transcripts, her commentary about throwing you in jail related to if we had asked for jail time in our motion to enforce, she would have granted it as opposed to some unilateral threat of jail? Isn't that correct?
Yeah, similar to the overnight. She said that if mom had asked for it, then she would have granted it.
All right. So she wasn't singling you out because of your hair, correct?
I can't speak to that.
Okay, well, she was singling you out because she said she would have for these actual violations if my client had asked for it, but we didn't, correct?
With respect to jail time, that was it, but there's no parallel comparison to threatening me with no overnights.
Okay. And you would agree with me that the court mid-trial made additional orders with regards to the notification requirements for travel based on testimony that came out in the first 2 days of trial, correct?
First 2, yeah, I was on the stand first 2 days.
Correct. And it was after you had testified about what you had done to purportedly notify my client where Judge Iserloh stepped in and said, you know what, we're not going to have this issue anymore. Here's what we are going to do for all travel henceforth. Correct?
Yeah, after I had, indicated that I had provided proper notice, she indicated that she would then want additional notice.
And that was because my client traveled on at least 2 different occasions to out-of-state locations to exercise her weekend possession during your extended summer possession. And you never presented the child for those periods of possession, correct?
No, you said, and that was because I don't know why Judge Iserloh did what she did. And during day 5, she wasn't even aware of the out-of-state travel provision anyway. So there's no way she would have done that on day 2, when on day 5, she admitted to not understanding child custody laws.
All right, Mr. Morris, I had an opportunity to cross-examine you within those first 2 days of trial, correct?
That's correct.
And in fact, I asked you about the summer possession, correct?
Correct.
And in fact, I asked you about these violations during my cross-examination of you, correct?
Correct.
Okay. And so your attorney had an opportunity during her redirect to readdress any of the issues that related to the motion to enforce by contempt, correct?
I don't know how to answer that.
All right. The court actually, based on those violations of visitation that occurred out of state the judge actually ordered you to reimburse my client for the travel expenses that she incurred to attempt or exercise her court-ordered possession, correct?
Correct.
All right. And the court made specific findings and found you in contempt for specific violations of the further temporary orders that described additional requirements for out-of-state travel, correct?
No, and there was evidence produced that showed I provided this.
Okay. And what the court actually commented was that respondent did not inform movement of the city in which respondent was traveling with the child during this travel period within the required time period. That's what the finding of contempt was, correct?
Right. Evidence was produced that we were in St. Louis. I gave multiple cities for Illinois, and then I gave the city we were in for Tennessee. And that was provided to the court.
And so your complaint with the court is that the court ignored your evidence, correct?
That's right. If I provide, actually, I mean, you provided it as well. It was in the form of a communication. So,
okay. Then we had an additional violation, the last violation related to therapy, correct, of the child?
yeah. And this was, again, I mean, this was made up. I didn't violate anything with therapy.
All right. So the court chose to ignore the evidence you presented and believe the evidence presented by Ms. Schaefer, correct?
In large part, yes.
All right. And the court assessed you attorney's fees in the amount of $16,527, correct?
For these enforcements, yes.
All right. And then also ordered the underlying cost for the travel my client used to, or expended to try and exercise her possession, $3,000, correct?
For these enforcements, correct. In addition to the almost $250,000 for other legal fees.
All right. And have any of those amounts been paid yet?
No.
Okay. And let's give the court a little bit of an idea about CJ. CJ suffers from dyslexia, correct?
She's been diagnosed with dyslexia, yes.
Okay. And actually, one of the contentions at trial was your disbelief that her dyslexia is as serious as it is, correct?
That's an allegation. I've never said that.
Okay. And she attends Ross and Saunders School, which is one of the leading schools in the area for children with dyslexia, correct? Or she's going to attend next year? She
attended 3 summer programs, and she currently attends this year.
All right. And so she also, in addition to having dyslexia, has some pretty severe anxiety issues that have had to been addressed throughout the course of this litigation. Is that right?
That is incorrect.
That's right. You don't believe she's got emotional issues, and Ms. Schaefer does, correct?
No, the only mention of anxiety was as of late with her most recent, now prior therapist, who mentioned
Weren't there
anxiety.
discussions?
It wasn't throughout the pendency of our litigation.
Weren't there discussions, Mr. Morris, at trial about how your child would urinate on the floor in front of a refrigerator on various occasions? Like she had incontinence issues when she had her anxiety attacks?
These are reports from Heather, and I believe those were reports from years ago, but those were only reports from Heather.
Okay. And so one of your positions in trial was that the child only had issues with Ms. Schaefer and never displayed issues with you, correct?
Those specific issues reported by Heather, correct?
Okay. And then the knife issue, Ms. Schaefer asked that you not bring the knife to doctor's appointments or school events, and that was discussed at trial, correct?
That was discussed.
All right. And in fact, there was a particular incident about your daughter's Bunny couldn't come to school for show and tell because you refused to leave the knife either in the car or at home, correct?
No, that's incorrect. It's not that she couldn't come to school. It's that Heather didn't want to go to school.
Okay.
Years later, even though I had a pocket knife the entire time Heather and I were in a relationship up until today. It's not that she couldn't go. It's that Heather developed a fear all of a sudden in the past year, and it is not um, it's not my job to mitigate her fears.
And in fact, the judge, when we had an injunction, there was nothing to actually vacate. The TRO expired, and the judge actually asked you, Mr. Morris, won't you just not bring a knife to school? Do you recall the judge asking you that?
Yeah, the TRO expired and was specifically vacated by the judge.
Okay. And so when it expired on its own, court asked you to leave the knife at home during doctor's appointments and other appointments. You refused, correct?
After the TRO was vacated, the judge did ask a request and also issued that or stated that she is not going to issue any ruling on that knife.
Okay. And another judge heard the evidence that you refused to honor a judge's request. Judge Islow heard that evidence, didn't she?
I mean, that's what you stated. I don't know. She also heard that the judge didn't issue an injunction when she very well could have.
I understand, but Judge Islow also heard the evidence, and I forget which judge, so I apologize. The previous judge that said,
It was Judge Cantu Hexel.
well, thank you, Mr. Morris, that Judge Cantu Hexel asked you to not take the knife around for these various appointments, and you basically said it was my constitutional right, so I'm not going to do that, correct?
I didn't respond with anything, actually.
Okay. But Judge Islow heard that evidence at trial or that testimony, correct?
I don't know about evidence or sure, testimony, sure.
Okay. And so let's talk a little bit about the closing arguments. Are you aware that a court and a judge have the ability to control the flow of their case, how they determine to be appropriate? Are you aware of that, Mr. Morris?
Somewhat.
Are you aware that a court can tell both counselors we are not doing closing arguments in a case? That's well within a court's ability to do so.
I'm aware in rare cases that happen. I mean, we weren't told that we weren't having closing arguments. She just went into hers.
Okay. And what the court actually brought out the bowl and water for was something called ACE, Adverse Child Experiences, correct?
That is something she mentioned.
Okay. And in fact, the entire discussion with the bowl of water and the sponge dealt specifically with ACE, Adverse Childhood Experiences, correct?
That was what was mentioned, but my thing was until it was specifically directed at and only me.
Okay. And what the court discussed was the long-term health risks with an increased likelihood of chronic diseases and mental health issues and risky behaviors in adulthood for children that experience adverse child experiences, correct?
That, I mean, was mentioned in a way, sure.
Okay. And in fact, the picture that she portrayed on the wall at trial was specifically from a child that was in an ACE study, an investigation. And it was artwork that child had drawn in that study to show how ACE had affected her, correct?
The picture was correct, but the subsequent banging and yelling and finger pointing was directed at me.
Okay. And what the judge did with the sponge and the bowl was to say, the sponge is your daughter. And if you put her in a bowl of vinegar with the bad co-parenting between you and Ms. Schaefer, she's going to soak up nothing but vinegar, which is the adverse child experiences, correct?
She said that, but she said that it's due to my ego
Okay.
and not
Um,
processing childhood
sorry.
trauma from events that never took place.
Okay. So what she said was based on the evidence that she heard at trial, correct?
No, there was no evidence presented that I had been molested.
Okay. And in fact, she didn't say you'd been molested. She said she had concerns that you may have been based on the other family history that had been presented, correct?
No, she specifically said dad had been sexually molested to the point that we are not going to have family members around child.
Okay. And that was actually one of Ms. Schaefer's specific requests, correct?
Yeah, in her PDI.
Okay. And you didn't make any specific requests that Ms. Schaefer not in with regards to the drugs, correct?
I don't recall. I'd have to look at my PDI.
Okay.
But the
And in
prior
fact,
temporary
the
orders
testimony.
was mutual.
I understand what's mutual at the time of temporary orders, but you would agree with me that evidence presented itself that at one point you were engaging in the sale of marijuana, correct?
To Heather's brother, correct?
All right. So there was evidence before Judge Iserloh as to you selling marijuana, correct?
No, I don't believe we talked about it at final orders. That
All
was
right.
temporary orders with Judge Arth in 2021.
And there was also, I'm sorry, I just lost my train of thought. And there was no evidence presented at final trial that Ms. Schaefer actually had any problems with alcohol or drugs, correct?
She testified that she also used drugs.
She testified that she used marijuana like one time early on in your dating relationship, correct?
No, that's
All
not.
right. But you would agree with me that Judge Iserloh did not determine, based on the evidence presented, that Ms. Schaefer had any issues with drugs or alcohol, correct?
Based on the evidence presented, there was no difference in mine and Ms. Schaefer's drug use.
Okay, well, let's pull up your proposed disposition of issues. If you give me just 1 second, Judge. Isn't it true you filed a judicial grievance against Judge Iserloh?
That is true.
And that was actually denied, correct?
No, not to my knowledge. It was actually taken in by the investigator and forwarded to the committee.
Okay. And you have not received any response from the committee showing any finding against Judge Iserloh, correct?
Not to date,
Okay.
but it was certainly not denied. It was received and forwarded on.
Okay, but you've not received any indication that it made any findings against Judge Iserloh, correct?
I've not received any indication that it was denied.
So that wasn't my question. Did you hear my question, Mr. Morris?
I've not yet received any indication that it was granted or denied.
Thank you. And when did you file that complaint?
That was in like November 13th, maybe.
So the same time you filed a motion to recuse?
It was before, I believe.
Okay. This is All right. I'm going to show, Judge, I'm going to move to introduce what I'm going to mark as P4.
R4.
I'm sorry. Thank you, Judge. R4, which is your proposed disposition of issues.
It's received.
Thank you. And these were filed. And Ms. Montoya, you may have to correct me on this. Did you file one post April 26, 2024?
Let me ask Tanae. We were pulling up our PDI too. So let me just check real fast.
I just want to make sure I'm correct. I don't want to make any misrepresentations to the court. That's the only one I have.
I've got one pulled up right now from 6/26/25. And I can share screen or we can shoot you an email if you want
Can you just shoot me an email with it, please?
Yeah, Tanae's gonna send it right now. It's
Thank you. I
Gmail.
appreciate it.
No problem.
Judge, the court report needs a short break, I just need to get that email because I
Okay.
can't find it in my file, the current one.
Yeah, I'll take about 10 minutes if that's all right.
All right, we'll break for 10 minutes. Thank you.
Thank you. Thank you, Judge.
Thank you.
And you may proceed, Ms. Locke.
Thank you. All right, Mr. Morris, I'm going to you have a proposed disposition of issues that you filed in this case, and your attorney so nicely provided me because I couldn't find my copy of it. With your proposed disposition of issues, and I think I'd move to introduce those as PR4, and the court admitted that. Is that correct, Judge?
Correct.
Thank you. And then I'll share my screen in just a second. All right. Mr. Morris, this is your proposed disposition of final issues that you filed with the court. Do you recall that?
Yes.
All right. And you made some specific requests relating to Miss Schaefer and her possession, correct?
Yeah, correct.
And in fact, you made a mention a little bit ago about when Miss Montoya was asking you questions about Miss Montoya's request for you to have basically a supervised possession or access until the child was basically 18, correct? Or no overnights. Do you recall that?
Yes, that's what Heather had requested, yes.
All right. And do you recall yourself requesting that my client not even have a standard possession schedule until she completes a second psychological evaluation?
Not until she completes, but would have a standard possession until the successful completion of.
Yeah, you requested that she not have possession or access of the child that she'd been primary conservator of since the court ordered it in 2021. You requested that in 2025, July, at final trial, that she no longer have access until she completes a second psychological evaluation, correct?
No, that's not what it says. It says that she would have a standard possession schedule until the successful completion of a second psychological evaluation. Once the evaluation is completed, 50-50.
Okay. So you wanted her to have basically what the court awarded you, correct?
With a second psych eval, correct?
Okay. Court, of course, denied that request, right?
That's correct.
All right. And then you made some specific requests with regards to you want the exclusive right to designate the primary residence, right?
Correct.
And you wanted the exclusive right to consent to psychological and psychiatric treatment, correct?
Correct.
Okay. Just out of curiosity, if the court had granted you those two requests, do you still believe that Judge Iserloh would have been biased?
I can't base it off of those two requests. I mean, I'm basing it off of the entirety of our hearing, of our 5 days.
And it's the entirety of her rulings, correct?
Right. What you're asking is speculative, and what I'm providing is facts and things that she had said. So I can't answer your speculations.
You actually asked that the court remove the injunctions on the motorcycle and the one wheel and all other devices or toys as previously listed, correct?
Yeah, absolutely. I believe they're unlawful.
Okay. And you also wanted the judge to enjoin Miss Schaefer from vaccinating the child without your consent, correct?
That's correct.
And you wanted her to leave the child alone or unsupervised with her brother, correct?
That is correct.
And the same prohibition from allowing her to have people around the child that have under the influence of illegal drugs near the child, correct?
That is correct, specifically as it relates to her brother and the testifying.
Right, but you didn't make any specific requests with regards to her alcohol or drug use, right?
I would have to read, but I
Well,
believe
it's not in here, Mr. Morris.
I believe it said from having the child around people under the influence, and I'm a person, so she's a person.
Okay. And you wanted her to be prohibited from interfering with her medical and therapy appointments, correct?
Correct.
And the request for no corporal punishment, correct?
Correct.
And you didn't want her interfering with possession, right?
Correct.
All right. And the judge did not grant your specific request relating to possession or access, child support, or your possession schedule, right?
That's correct.
All right. Although the judge did grant your one request, she named you all joint managing conservators. Do you think the evidence supported her ruling on that and naming you a joint managing conservator?
She made me joint managing conservator with deleterious injunctions and providing Heather with all medical decisions. So I'm not clear what joint managing conservator is in this when it's effectively sole conservatorship.
Okay. And so, but you would agree with me under the law, she granted your request and named you a joint managing conservator, correct?
That is what it said. And then, yeah, everything else
Objection
after that,
non-responsive.
I don't know how it's joint.
And you would agree with me that the evidence supported Judge Iserloh's ruling in naming you all joint managing conservators, correct?
The evidence supported, no, because like I said, I don't, all the injunctions and everything else after that, it's not joint. I'm not sure what's joint about it.
Okay, well, you understand there's a distinction and delineation in the Texas Family Code between rights and duties and appointment of conservatorship, correct?
Sure, rights and duties,
Okay.
of which I have none. So
And
I don't understand how it's joint.
And the presumption is, and under the Texas Family Code, that joint managing conservatorship is in the best interest of the child, correct?
Again, that's what it says, and I don't understand how it's joint when all rights and managing duties are removed. Well, I don't understand what
So,
is
Mr.
joint
Morris,
about.
I'm not asking you what you understand, okay? I'm asking you what the order says and what the court ruled. And the court ruled and named you a joint managing conservator, correct? Yes or no?
That is correct, and they
All
rule
right.
that
Do
I
you
don't have any
do you
say in any of the subsequent items.
okay? Do you believe that the evidence supported the court naming you, and I'm not talking about rights and duties, I'm talking about conservatorship. Do you believe the evidence supported the court appointing you joint managing conservator of CJ?
I don't know how to answer that.
What part of that question did you not understand, Mr. Morris?
The difference between joint and managing of duties, and then duties that were taken away that I'm not managing.
Well, let me ask you this way. Would you be happier if the court ruled that my client would be sole managing and you'd be possessory? Is that a better ruling, what the evidence supported, based on what you're telling me now?
With the evidence supported, no.
Okay. So the evidence did in fact support an award of joint managing conservatorship, correct?
Okay. Yes.
Is that a yes, Mr. Morris?
That's a yes.
Thank you. And I'm going to introduce finally Judge R5, which is the underlying order.
All right, it is received.
Thank you. Let me share that one. And Mr. Morris, while I'm trying to get my computer to share that screen, there was evidence submitted through the attorneys via affidavit of attorney's fees, along with accompanying redacted invoice statements by both attorneys, correct?
Yes, I believe that's correct.
Okay. And so there was evidence presented to the court as it related to attorney's fees incurred by both sides, correct?
Yeah, I don't know about presented versus submitted. I believe it was all submitted.
Okay, and you believe it was all in fact introduced and accepted and admitted into evidence by the court, correct?
Yes, introduced and accepted, correct.
And our affidavit our Ms. Schaefer's included requests on what would happen on appeal with regards to attorney's fees, correct?
Yeah, that is correct.
And in fact, we also delineated it in our request for proposed disposition of issues, the attorney's fees on appeal as well, correct?
I believe that's correct. Yeah.
Okay. And so there was evidence before the court as it related to attorney's fees incurred trial and what was anticipated would be incurred if you appealed this case at various levels, correct?
Yes, that's what you outlined.
Okay. And so Judge Eislow had all of that information in front of her, correct?
To my knowledge.
Okay. And you just don't like that she awarded the fees, not that there was no evidence supporting them, correct?
No, that's not correct. I mean, she awarded the entirety of her attorney's fees and then future fees and sanctions should I pursue an appeal.
Okay, well, let's go over the actual order that's in your final order. The court ordered $222,995 in reasonable attorney's fees, expenses, and costs incurred by Ms. Schaefer, right?
That's what they awarded.
Okay.
I don't understand what it's based on, but
did you not hear a second ago me talk about the attorney's fees affidavits and the billing statements that were attached to those affidavits and introduced into evidence?
right, but I'm being ordered to pay to fight and assert my constitutional rights to my daughter for the past 4 years.
Are you aware that it's within a family court's authority, a judge, to make a ruling? It's at their discretion on attorney's fees if the court determines that an award of attorney's fees is appropriate given certain facts and circumstances.
At the discretion, sure. It's unclear what those facts are.
Okay. But you would agree with me there was evidence in the record that supported the amounts listed in this order.
No.
There was not evidence that my client paid $222,995 for reasonable attorney's fees.
I mean, your invoices or affidavits, sure, that's evidence that she paid that.
Okay. And then there was a specific award for attorney's fees on appeal, correct?
Correct.
All right. And so this occurs, these are not in effect now. They're only triggered if you appeal this case, right?
Yes, if I pursue an appeal, correct.
All right. And you mentioned a second ago something about sanctions. Can you point out where, and we'll go paragraph by paragraph, where are there sanction amounts in this award?
I'm not an attorney. I might have misunderstood the sanctions versus awarded judgments versus fees.
Okay.
But it's my understanding that I'm being I mean, isn't that what the first $229,000 is? Sanctions. Isn't that what these appeals are? It's like sanctions against me. Should I pursue an appeal?
So if you decide to pursue an appeal, there is a $20,000 judgment for the appellate fees, correct?
Yeah, should I pursue an appeal to assert my rights?
And do you see where it says it's further ordered that the judgment of attorney's fees on appeals rendered against Mr. Morris is conditioned on his pursuit of an ultimately unsuccessful appeal, so that if you win, there is no judgment for those appellate fees?
Okay, but if I assert my rights to my daughter, then I pay?
Okay.
Is that what it says?
Mr. Morris, you're was an electrical engineer?
Mechanical engineer.
Mechanical engineer, that's right. And you own your own business, a successful business that you've testified to previously in court, correct?
That's correct.
And in fact, in your motion to recuse, you've delineated to the court you are an intelligent, capable, smart man who runs a very successful business, correct?
I didn't use those words, but I do have my own business.
And so what this says is that you only owe the $20,000 if you are ultimately unsuccessful on the appeal. Do you understand that?
Right. So it means I owe $20,000 if I pursue an appeal to assert my rights and I lose.
Okay. And then there's a fees related to Texas Supreme Court. If you appeal to Texas Supreme Court and there's no argument, correct?
The same, yeah. If I pursue
All
an
right.
appeal to assert my rights, then I am pre-fined.
So your complaint really, Mr. Morris, is that you feel you're being penalized because you're asserting your rights to your daughter with these fees. Isn't that correct?
In part, correct.
Well, what's the other part, Mr. Morris?
The entirety of this recusal, I feel, in addition to the penalties, those penalties are based on bias statements and actions of the judge. In addition to being biased, I'm also being financially penalized. And the judge said at the end of day 5, off record, that she has other means to use against me and that she doesn't want me back in court. So if I believe and have shown through facts that she is biased and she's also penalizing me financially to even assert the rights that I have and the rights that I had to pursue because I'm being denied my daughter and attempted to being denied access to our daughter.
Well, you have a standard possession order, correct?
I do now.
Well, you had only a little bit more. You had an expanded standard, correct?
That's a lot bit more.
Okay. And the court actually had commentary in its ruling about the child needing, because of her special needs, needing to have a pretty good schedule when it comes to school, right? So going to bed early and on time and being rested so she could focus at school. Do you recall that?
That's what the court said, and that's what happens when Cameron's with me. There's no evidence other than Heather's narrative that says otherwise. There was no testimony from any of her professional providers, any of her therapy or mental health providers, any of her educational providers that say that I did not, I don't know, present my daughter well rested or take care of her physically, emotionally, psychologically. There's no evidence against that.
Okay. And Mr. Morris, you're aware that despite you saying all those statements, that Ms. Munivar found that you engaged in gaslighting behavior towards Ms. Schaefer as it related to parenting and CJ.
I can't speak towards her state of mind. I saw the footnote, but also of note, her report was void of lots of mentions of Heather's activities, specifically mutual drug use, lots of stuff.
I pass the witness, Judge.
All right. Ms. Montoya, if there is an item you need to clarify, you may do so, but I don't want to rehear everything.
In Michelle Munivar's report that was admitted over our objections, did she mention any risk or any sexual molestation issues or whatever with respect to your father and your brother?
No.
Even
No.
right? Didn't she call your dad?
She did, as a collateral.
As a collateral. So that never even came up into evidence, correct?
That's correct.
Right. The only time that was mentioned was back in 21 with respect to, I think, your brother, I'm trying to recall, but Judge Arth, and Judge Arth said, no, I'm not going to order that injunction, correct?
That's correct.
Because there's no evidence of any risk with respect to them, correct?
That's correct. There's no
Had anything changed in 4 years?
No.
Was there any evidence presented by anyone that they were a risk to your daughter?
No.
Even in the report with Munivar, correct?
That's correct.
So the injunction should not be ordered if there's no evidence of it, correct?
That's correct.
But Judge Iserloh ordered it, she said, specifically because you had been sexually assaulted, correct?
That is correct.
Is that in any report anywhere?
No, there's
But
no mention of it, no evidence, no nothing.
so you're saying to Her Honor that this injunction shouldn't even happen, correct?
That's correct.
And it's based upon facts that don't exist, correct?
That is correct.
And then the proposed disposition of issues, Ms. Locke, I don't know what exhibit number it is for you, but I'm going to borrow it back. RPDI.
Which one?
RPDI that Tanae just sent that in June. What number? What are you calling it?
It's number 4. It's number 4.
I'm going to refer back to Ms. Locke's number 4, response number 4.
Yes.
Okay. In it, we do ask that there be injunctions against mom's brother, correct?
That's correct.
Right. And there is concerns about his drug use all the way back to 21 with Judge Arth, correct?
That's correct. And it was testified to by myself, Heather, and he was also.
And he testified. The brother testified about his drug use, correct?
Yes.
Yes. And yet you're asking for the same injunctions that they want against you. And you could not get that, even though there's evidence, and there has been evidence on the record for years about her drug use and her brother's drug use, correct?
That's correct.
Okay. So you're only saying that you are the one who has this injunction when the evidence shows that there should be at least a mutual, correct?
Yes.
Okay. Okay. And Ms. Locke, I asked you about the joint managing conservatorship. Do you recall?
Yes.
Okay. And the order, if you recall, it states that Ms. Schaefer has exclusive right to make medical, psychological decisions, correct?
That's correct. And educational.
And educational decisions, correct?
Yes.
All right. She only has to inform you, right?
That's correct. Yeah, there's some loose verbiage about conferring with me, and then I don't know, after some time frame she can make the decision, but yeah, she has exclusive rights.
Right, doesn't it say, I believe it is respondent, I believe they pulled up the order. We have it too, but I believe it's on page 4 of the order. And it's in evidence. It specifically says if you can't reach some type of agreement within 48 hours of all medical, psychological, all of those decisions, correct?
That's correct.
Heather makes the decision. She's the tiebreaker, correct?
That's right.
Is that your confusion as to what joint managing conservatorship is if she's the tiebreaker?
Yes, absolutely. I don't know what the joint part is. And I don't know what I'm managing if she makes exclusive decisions on all matters.
On all matters with respect to your rights to your daughter, correct?
That's correct.
That's what it says on page 4, and it goes into that onto page 5, correct?
That's correct.
All right. I'm going to go back to the original questions. Isn't it Dr. Tao or it's Ms. Tao who is now going to be your parenting coordinator or facilitator versus Shar Wittenberg? Do you recall that?
Correct. Shar Wittenberg was our previous coordinator, and then Tao Fan is our current facilitator.
Okay. Was there anything in the proposed disposition of issues to have some case manager, some case manager on this by opposing counsel, by Ms. Locke or Ms. Schaefer?
In the PDI, no.
No, it never came up, correct? That was something that Judge Iserloh had come up with, correct?
That's correct.
But they were already asking for Ms. Tao to come on, correct? So that she could testify versus Shar Wittenberg, who could not testify to what was going on, correct?
That's correct.
Okay. And that was Judge, you wanted to have a man do it, right?
Yeah, she specifically said that she thought it should be a man or a male.
Do you see in the order where there is travel restrictions with your daughter that you can't even travel out of country unless they agreed to the Hague Convention?
Yes.
Was there any evidence that you would take your child to a non-extraditable country?
No.
But it's there permanently, right, for the next 8 years?
That's right.
So you couldn't say go to, I can't name a country, but you can't go to any country you want to. So your travel with your daughter is restricted for the next 8 years too, correct?
That's correct.
With no evidence that you would take your child out of country and never come back, correct?
That's correct.
Was there any evidence that you were a flight risk ever presented to the court in all of these years?
No.
Did you have the opportunity to redirect? Do you know what I'm asking? Sorry. For a redirect, Ms. Schaefer testified and then you're going to get back on to redirect?
Are you asking the court? Who are you asking?
I'm asking Mr. Morris, but then I got technical and I had to kind of see if you knew what I was talking about.
No, it was, I think, last day of trial in the morning. Ms. Schaefer was on the stand, and then we took a break, and then judge came back with her ruling.
Judge came back with a sponge and then the whole, what you say, 25-minute
That's correct.
closing, right? Yes. Okay. Let's go to the knife briefly. It was Judge Cantu, you said Judge Cantu Hexel had vacated, even though it was technically vacated, but she had vacated it. She said it multiple times, right? She was vacating the TRO.
That's right.
Did she not examine Ms. Schaefer herself?
Yes, we were all present.
Did she not ask Ms. Schaefer questions about who canceled the dentist appointment? Was it the dentist office that canceled the appointment, or was it Ms. Schaefer who canceled the appointment?
She did ask that question.
Right? Because Ms. Schaefer had presented in the TRO that you were a danger, correct?
Correct, yeah.
Okay, and then come to find out, what did Judge Hexel Cantu discover about that dentist appointment?
That it was Heather who had canceled it on her own volition. The dentist was not involved at all.
Right. Okay. Okay, Your Honor, I'm going to pass the witness. Oh, are we done? Yeah,
Thank you. Thank you.
Oh, and Your Honor, if I wasn't clear, my apologies. I was using respondent. They have the final order that was signed in October. I was referring to that when I was asking about the exclusive rights and duties. So I want to make sure that that's clear. I was borrowing theirs, like they were going to borrow.
I understand. Thank you. Ms. Locke.
Judge, I truly have, as attorneys say, one last question. I have one last question.
All right.
Mr. Morris, you'd agree with me that the international travel restrictions apply to Ms. Schaefer as well, correct?
I would have to see. I don't recall if that was mutual or not.
Well, now, Judge, I have two, but let me just pull up a portion of the order.
Okay. Go ahead.
I'm trying to pull up the provision in the order, Judge, if you'd give me just a second. Mr. Morris, you've read the order, correct?
Yes.
All right. And you know that the Hague Convention restrictions on travel apply to both you and Ms. Schaefer, correct?
I do not know that. I just stated that. I'd have to see.
Well, you were making a complaint just now that there was another error by Judge Iserloh that was another reason is you were restricted from traveling with her to certain countries for 8 more years. Do you recall that?
That's correct.
Well, doesn't your argument change if, in fact, my client is restricted in the same manner and means as in which you are?
Well, I haven't seen that that's the case. Regardless, it's still a restriction on my travel with my child.
Judge, it's in the order. It is mutual. I would just ask the court to take judicial notice in the order of that mutual injunction on international travel for the Hague to members of the Hague Convention on kidnapping and international abduction. It applies to both parties. Mr. Morris is not singled out.
Thank you.
I have no other questions.
Thank you. You rest, Ms. Montoya?
For the record, Your Honor, it's on page 48 of the order.
Oh, am I wrong, Ms. Montoya? I would love, if I'm wrong, I will retract my entire argument.
It's on page 48, that the Hague Convention, I'm just pointing, it's on 48.
Yeah, I think it applies to both.
Is it mutual?
No, it's not. It says this order that David Morris is permanently enjoined from, and then it's item number 7, traveling with the child to any country that is not a signatory or compliant with the Hague Convention.
I have to go back to her injunctions, Judge, as well.
Yeah, it would only be under your name because it's specific to you, but Ms. Locke's going to look to see if it is perhaps under Ms. Schaefer.
And Judge, if I misspoke, then I absolutely withdraw my discussion on that particular issue. My job is not to misrepresent anything to a court, but I thought there was mutuality on it.
It's
but
on
if
the
I'm
top
wrong,
of 48. It's on the top 48, and it says it is ordered that David is permanently
Morris,
joined.
he's permanently joined.
Motorcycle, and then the grandpa and the brother, and then that's all David.
Judge, I'm the first attorney to admit when I am wrong. And if I misspoke, which apparently I did, then I absolutely withdraw my statements to the court. It does appear that the injunction is solely against Mr. Morris, but I do believe that the evidence supported those specific restrictions anyway. So it doesn't change my ultimate argument, but I did misspeak and I apologize.
Thank you. All right. Now, Ms. Montoya, do you rest?
I have the one more. Sorry, we went one more. Can I have one more? Just one more, please.
All right.
While we're there, Your Honor, on page 48, it also has a restriction against you, David, and it says you can't attend medical, psychiatric, or dental appointments that are scheduled to occur during her periods of possession at all, correct?
Yeah, that's correct, which is all midweek when doctors are open. So yeah, it effectively removes me from all medical appointments unless there's some one-offs during I don't know, holiday or summer but I've been involved in and with all these appointments with my daughter since birth.
Is there any evidence that you could not be at your daughter's medical appointment?
No.
Was it your concern? There was a question about, you were talking about another psych evaluation for Ms. Schaefer. Do you recall Ms. Locke asked you about that?
Yes.
Okay. Were there not concerns of, they don't say Munchausen's now, it's something by proxy. I think it's fabrication.
It's factitious disorder imposed on another.
There it is. Thank you. And there were questions about that because even as of today, Ms. Schaefer is reporting these anxious behaviors, psychological behaviors, even right now at Rawson, but they only occur with her, correct? Not with you.
That's correct.
Right. It's come up with the professionals repeatedly, correct?
That's correct.
That Ms. Schaefer reports that the child is experiencing all of these dysregulating behaviors and these issues, but it's not in your care, correct?
That's correct.
Okay. So you weren't saying no access, you were asking for another psychological evaluation with someone you believed was not biased because Ms. Monavar was not working with you, correct?
That's correct. Yeah, there was extended periods where Ms. Monavar and I had no contact, and apparently she was receiving information from the other side.
Her the entire time. How long did it take to get the psych eval from Ms. Monavar completed? Wasn't it ordered in 21?
It was ordered in October 21, and she didn't complete it until September 2023.
Right, it took almost 2 years for her to get that, correct? And how many times did you talk during the 2 years?
Often, I mean, to provide collaterals, we did the whole gambit of, everything that's involved in a forensic eval, the tests, the interviews.
Right. But
everything.
after her report was completed and what ended up in this trial, did you talk to her thereafter?
No, from September 2023 through her deposition in June, I had zero contact with her. June
So we were not
2025.
present, correct? We were not
Correct.
present, correct, at the deposition?
Correct.
Okay, all right. Okay, Your Honor, I'll pass the witness. Thank you for your patience.
Thank you.
Nothing else, Your Honor.
Thank you. Very often judges just go into the ruling. They don't ask for closing arguments. And I'm not going to ask for closing arguments, and I'm going to give you my ruling. Mr. Morris, I understand your grievances are based on the way rulings went, but very rarely are the court's rulings the basis for a recusal. And I understand your position that you believe there was a bias against you. If there is evidence that's presented to the judge and the judge receives it in a certain way and relies upon it in making its rulings, if it's legally correct, that is what the way the judge felt it should be. But if it is not legally correct and the evidence does not support it, that is a matter for an appeal. But my ruling here today is simply to determine whether or not you're asking me almost in retrospect to review this trial and say the judge was unfair to you. I know you believe the rulings were unfair to you, and it may be, but these are matters that are best addressed in an appeal. The majority of the complaints that were raised were with regards to the rulings that favored Miss Schaefer and did not favor you. I cannot look into the judge's thought processes and try to figure out why she did what she did. Comments like the ones that she made, behaviors like spitting on the floor or acting like she's spitting on the floor, those are not dignified behaviors. And they are certainly, there's no place in the courtroom for that from the person who is expected to set the decorum in the trial. And so I cannot excuse or justify or even try to explain why she did what she did. But the majority of your complaints are based on the perceived unfairness or the actual unfairness to you, Mr. Morris. But again, those are matters for an appeal. Rulings cannot be. Very rarely are they. Very rarely are they. And I don't see this to rise to that level. And so the motion to recuse is denied. Thank you so much, and good luck to you.
Thank you, Judge. Are we excused?
Yes, thank you.
Thank you.
Ms. Goodman.
Thank you, Your Honor. Merry Christmas. Happy holidays.